everyone. For folks joining, we're going to give it about 1 more minute for people to get into the Zoom, and then we will get started. Hello, everyone. Welcome to the Environmental Law Institute's webinar, The Endangered Species Act at 50, Successes, Shortcomings, and a Discussion of What's Next. My name is Madison Calhoun, and I'm the Senior Manager of Educational Programs here at ELI. We have a great program lined up for you today. December 28th will mark 50 years since the Endangered Species Act was signed into law. In celebration of the 50th anniversary of the statute, we decided to hold a program to explore the successes and shortcomings of the statute, as well as discussing what might be ahead for the ESA. I want to take a moment to thank all of our fantastic speakers for being here with us today and for taking the time to prepare informative content for this program. I also want to thank our audience for tuning in. We so appreciate your engagement. Webinar will feature commentaries from our 4 wonderful panelists, as well as a roundtable discussion. Many of the panelists contributed to a recent debate article about the ESA, which was published in ELI's journal, The Environmental Forum. If you haven't had a chance to read the debate, we will put a link to it in the chat momentarily. We'll be taking questions from the audience as we go, so please submit any questions you have for the panel using Zoom's Q&A function at any time during the program. The chat will also be open, and we welcome you to use it to post any observations or comments you have throughout the program. If you have a question that you wish our panel to address, though, please do put it in the Q&A box, not in the chat. Today's webinar will be recorded and posted on the event webpage for ELI members to view later. So if you're an ELI member and unable to view the entire webinar, you are welcome to watch the recording, which will be available within a few business days of the event. If you'd like to become an ELI member, you can find more information about that at eli.org/associates-programs. I will go ahead and turn things over to our moderator, Charmaine Morrison. Charmaine is a senior associate attorney with Earth Justice's Biodiversity Defense Program, which engages in national litigation to confront the major drivers of biodiversity loss. Charmaine received her JD from NYU School of Law, where she was a Root Tilden Kern Public Interest Scholar. She received her BA in Sociology from the University of California, Berkeley. Charmaine, I will turn things over to you. Thank you all so much.
Thanks, Madison. Good afternoon, everyone. Thank you so much for joining. I'm going to start by introducing our 4 panelists. J.B. Rule is the David Daniels Allen Distinguished Chair of Law at Vanderbilt University Law School, where he also serves as Director of the Program on Law and Innovation and co-director of the Energy, Environment, and Land Use Program. Before joining the Vanderbilt faculty, he taught at Florida State University and Southern Illinois University. And prior to entering academia, he was a partner with Fulbright and Jaworski, now Norton Rose Fulbright in Austin, Texas. He received his JD from the University of Virginia, an LLM in environmental law from George Washington University, and a PhD in geography from Southern Illinois University. He is an elected member of the American Law Institute and the American College of Environmental Lawyers. Derb Carter is a senior attorney in the Chapel Hill, North Carolina office of the Southern Environmental Law Center, which he joined in 1989. From 2005 to 2022, he was director of the North Carolina offices of SCLC, in addition to litigating cases in state and federal courts. Prior to this, he was director of the Southeastern Natural Resources Center of the National Wildlife Federation and an attorney with the Solicitor's Office, Department of the Interior in Washington, D.C. He received his undergraduate degree with honors in biology from the University of North Carolina and his law degree from the University of Oregon. He is a fellow in the American College of Environmental Lawyers and was inducted into the North Carolina Conservation Hall of Fame in 2023. Sean Skaggs is a partner at Edmund Moser and Skaggs in San Diego, California, where his practice has focused on natural resources law for the past 20 years. Prior to forming Edmund Moser and Skaggs, Sean served at the Department of the Interior for 10 years, where he was involved in the development of the No Surprises Rule, the Safe Harbor Rule, and the 5-point HCP policy. Sean is currently editor of the Endangered Species chapter of the American Bar Association's Year in Review. And finally, Bill Snape is a professor and assistant dean at the American University's Washington College of Law, where he also directs the program on environmental and energy law. Snape, in addition, serves as a senior counsel to the Center for Biological Diversity and still litigates on endangered species, public lands, climate change, and freedom of information issues. He is the author of many articles on the ESA and most recently published a chapter entitled Biodiversity Litigation in the USA, Strong Conservation Laws but Challenges with Enforcement, in a global compendium published by Oxford Press earlier this year. Thank you, panelists. Welcome. I just want to reiterate what Madison said. The panelists agreed in advance that they want questions from the audience throughout, not just at the end. So please feel free to drop them in the Q&A box, and I'll do my best to keep an eye on it. So let's dive in. I want to start by asking our panelists to share their reflections on the effectiveness of the Endangered Species Act 50 years since its enactment, and ways in which they think the act could be made more effective. Let's start with you, JB.
Thank you, Charmaine, and thank you to ELI for organizing this panel. It's an honor to be on a panel with such great ESA figures, and welcome to all our participants. So I'm going to throw a little curveball into this. As I was contemplating the theme of the panel, and sketching out some notes to myself about my reflections on the ESA, I thought, wait a minute, why don't I do what all my students are doing and ask ChatGPT? And so I had a nice conversation with ChatGPT. We are focusing on using it in legal applications at Vanderbilt. We have training on prompt engineering, and it did a pretty good job, although it has some shortcomings of its own, and I'll get to those later in the panel. But in a very, very broad brush, I asked it, what do you think are, and I explained what the ESA is, and what do you think the successes and shortcomings have been over the last 50 years? And it matched up actually quite well with where I was going. And I'll just go through them, and I want to come back to one in particular that I think is overlooked as a success. But the 5 categories that it identified, it asked for just 5, were recovery of iconic species, and I think we'd all agree that has over time placed the theme of endangered species in the public discourse successfully. And I think that's helped the Endangered Species Act sort of stick, notwithstanding all of its controversy. The second was habitat protection and conservation plans. And we have, in fact, extended a tremendous amount of protection through the HCP and regional habitat conservation plans and mitigation. So I think I would agree that's a success, and that's been very targeted habitat conservation. Third, ChatGPT, collaboration and partnerships, pointed out that the ESA has been a catalyst for collaboration between federal agencies, between federal and state agencies, local agencies, and collaboration even with private landowners, and particularly in the Babbitt era, where Secretary Babbitt really reached out and developed programs that facilitated those kinds of collaborations. A fourth was global impact and leadership, that the ESA has positioned the USA as a leader. I think it's, an environmental law we're proud of, along with NEPA in particular, in terms of its global impact and modeling for other nations. The fifth success story, scientific research and monitoring. And I'm going to come back to that. I'll just briefly tell you what ChatGPT said were the shortcomings or failures. And really, I think they're more problems, challenges, not necessarily shortcomings. Quickly, inadequate funding and resources. Well, that's not the ESA's failure. It's our failure to fund the ESA adequately. The second was political interference and delays. Yeah, that's not the ESA's failure. It is one of its greatest challenges, We've seen periods of tremendous political backlash. Insufficient habitat protection. Well, sure, GPT, we always want more. Conflict with economic development, that has been a source of controversy. And limited success in actual recovery, that's the standard criticism of the ESA. It hasn't led to recovery. On the other hand, of course, it has prevented, we would think, thousands of extinctions through its process. But that point about actual recovery brings me back to the scientific research and monitoring, right? We've learned that recovery is hard. I think the premise of the act, perhaps not explicitly, was, extinction is kind of this linear process. And then when we decide to develop a recovery plan, we sort of make that happen. And we didn't know at the time that recovery of a species that's been brought to the brink of extinction is actually very hard and could take hundreds of years. 50 years is probably not enough for most species. So we've learned that, and we've learned so much more because many environmental laws are known to have a technology forcing effect, right? They're forcing better technology for pollution control. But many environmental laws also have what I would call a science forcing effect, right? So Section 404 of the ESA created a science of wetlands. Might not be as robust or relevant after the Sackett opinion, but in other words, we learned more about wetlands because they became an important regulatory phenomenon. Superfund, CERCLA, we learned a lot about groundwater hydrology because that became one of the key threats that CERCLA was designed or ultimately remediating, and the liability was so high. The ESA, to me, one of the sort of understated success stories is its science forcing effect, learning more about species dynamics, learning more about how ecological disturbance threatens the viability of species, learning about how species interact with ecosystems, concepts like distinct population segments, foreseeable future, critical habitat that really prior to the ESA weren't in the science dialogue, but were forced into it as a matter of law. And now I think has really led to a tremendous amount of improved scientific knowledge about species and their fate. It made us think harder about concepts like how far into the future can we look and predict a species viability. Again, recovery is hard, and all of this is nonlinear. It's complex ecological dynamics that we're learning more and more about. A lot of this scientific study would have happened without the ESA, just as a matter of original research that scientists engage in. But I think the ESA is really focused and amplified the amount of scientific research that we have about species. Again, relying on ChatGPT is something that we want to be careful about, but I think it did a nice job capturing the themes that are out there. I mean, ChatGPT is just reflecting what it finds on the database. And I don't think any of these are big surprises at all, but I think that we can chalk up a good number of successes to the ESA over the past 50 years, even in the face of the criticism that it hasn't recovered, hundreds of species yet. So I'll stop there. I'd love to hear about other panelists' perspectives, and then maybe we can jump in a little bit with back and forth.
Thanks, JB. I did not see ChatGPT coming. A curveball indeed. Let's pass it to Derb.
Thank you, Charlene, and welcome to all those that are tuning into the webinar. I want everyone to know it is a absolutely perfect fall day in Chapel Hill, North Carolina. Couldn't be any nicer. I'm going to just appreciate the opportunity to share some perspectives on the Endangered Species Act, both looking back, but also some perspectives on what can be done to improve the Act moving forward. I view it over the past many decades as being a generally effective and resilient law, given the challenges that the law is trying to address, which is protection of our endangered species and their recovery and restoration of ecosystems. Some estimate that it's prevented 99% of the species that have been listed have not gone extinct. You've got to view that as a general accomplishment. Last week, the Fish and Wildlife Service delisted 21 species, half of them in our region, 9 mussels and Backman's warbler, because they have gone extinct. So that's a somewhat somber wake-up call that we've still got work to do. Most of those species actually did not get the full benefit of the law because they were either already extinct in many's estimation or at the verge by the time they were listed. Another measure of success is that one assessment showed that once a species is listed, in most cases, its population increases. Even though it may not recover, it's on a path, at least, toward recovery, showing that the requirements of the law can and do work. Unfortunately, as JB mentioned and ChatGPT confirmed, a big problem is getting to recovery, which is, of course, the ultimate goal of the Act with respect to species. And that, unfortunately, has lagged. Fish and Wildlife Service estimates that over that 50-year period, about 100 species that have been listed or have either been recovered or at least downlisted from endangered to threatened. So progress, but there could be a lot more in terms of that ultimate goal. I think finally that kind of legal framework that's been put in place has been very durable. It's been supplemented by use of habitat conservation plans, candidate conservation agreements, safe harbors, and other innovative tools that have made the law very resilient over time. I think how the Act could be improved, make 3 points. And I would begin with what is already underway, which is a repeal of rules put in place by the previous administration that would really set back efforts to allow the law to do what it's intended to do. Those rules would have allowed the consideration of economic impacts in deciding to list species, would repeal longstanding blanket protections for threatened species, and would define habitat in a narrow way that would not allow us to respond to some of the challenges that we are facing when critical habitat is designated. Repeal of all those rules has either been completed or underway by the Biden administration. So that's a good step, in my view, in kind of righting the ship in terms of moving forward. As JB mentioned, funding has always been an issue with the Endangered Species Act. There's a lot to be done. It costs a lot, both to meet the legal responsibilities and in a bigger way, supplement the various efforts that are underway to protect and recover endangered species. More funding is needed. There's a good influx of funding now from the previous Congress and the Biden administration for broad-scale ecosystem restoration, land protection. The Biden administration has characterized this as once-in-a-generation funding. In my view, it needs to be sustained into the future if we're going to meet the challenges of restoring these ecosystems and protecting endangered species. And finally, I think it's time to really integrate the more strict legal framework and efforts that are underway under the Endangered Species Act into a much broader effort to, as a country, to really focus on ecosystem restoration at a landscape level where we can identify, plan, and fund efforts to protect the critical parts of our country that still remain somewhat wild and support endangered species. It's all happening in a very haphazard way, but I think a bigger coordinated effort that would supplement the legal efforts and framework put in place by the Endangered Species Act not only would go a long way toward meeting these goals, but is really necessary to address many of the challenges we have in protecting our biodiversity, wildlife, and these really important parts of our nation. So that would be my 3 main points on how we could move forward.
Thank you, Derb. And I see we have some great audience questions coming in. I want to give Sean and Bill an opportunity to answer this first question, and then I'm going to turn to some of the great audience questions. So Sean, why don't you go ahead?
Sure, thanks. And no chat GPT, but I did want to look at this from the perspective of climate change. Mostly what we've been talking about is how does the act, is it effective in the face of climate change? What do we need to do? And I would make the case that, it's an interesting piece of legislation, and it's not really locked into the 1970s or even into the 80s when Section 10 habitat conservation planning amendments came into the act, that it's flexible enough to accommodate new threats. And so, I would make the case that because of the way Section 7 consultations are structured, that it requirement for best available science to go into those consultations, and the courts have interpreted that to mean that you cannot ignore a fundamental aspect of the problem, which these days is climate change. And so we've seen in Section 7 consultations the agencies wrestling with these issues for quite a period now, especially in the larger public water projects. I would also note that, the no surprises rule that came about in the 90s as part of the regional habitat conservation planning programs that the Babbitt era brought about, it included concepts that, again, help you adapt to new threats. And so there was the requirement to plan for changed circumstances. I don't think we've ever really seen a program like that before, where the mitigation wasn't really done. You locked up the land, but you really weren't done. And the management had a requirement to specifically consider and fund changed circumstances, which from the onset have always been the types of factors that are implicated by climate change. So increased floods and fires and invasive species and drought were all explicitly considered on the front end for these very large regional habitat preserves. And so I think in that sense, it was essentially an act ahead of its time, or the innovations of the 90s were ahead of its time, and that they're actually serving well in this changing dynamic, at least, within certain parameters. Obviously, we can get to the point where we hit the tipping point and all of this becomes somewhat of a academic debate. But I would also emphasize the other innovations like the Safe Harbor program that led to the conservation of millions of acres for the benefit of species. So that's really, I think, what I would argue has been very effective, is especially the regional conservation plans for non-federal projects. And we need to see a lot more of that. We need to see it kind of exported beyond the Western United States. For me, the ways the act can be made more effective, we have right now in the rulemaking that's out with the Fish and Wildlife Service and NIMS, we have the proposal to finally require compensatory mitigation in Section 7 when we don't have a jeopardy impact. So this would essentially bring Section 7 and Section 10 into the same kind of area in terms of what's required to offset impacts like incidental take. And so for the first time, Section 7 would require compensatory mitigation, essentially habitat acquisition in non-jeopardy situations. I think that makes sense, and it also just balances the act so people don't try to stay away from Section 10 and go hunt down Section 7 to not mitigate. We also see that the Section 7A1 for federal agencies has a lot of promise, but really hasn't ever become what it could be, for example. And we see, as kind of to Derb's point, we see a lot of uncoordinated actions that actually could be put together better for species. But, you know, BLM right now has a proposal out under FLPMA. It's not really ESA directed, but it would provide for conservation at the landscape level. And it emphasizes protecting intact landscapes and restoring degraded habitat. So that's obviously something that would fit very well under Section 7A1, wherever there were listed species. And I think that would be it for my opening remarks.
Thanks, Sean. Over to you, Bill.
Well, either the good news or the boring news is I haven't really disagreed with anything yet, which is a little no fun, but nonetheless, I think some very cogent things have been laid out. And I know we've got some questions piling up. Let me try to make 3 succinct points that try to wrap some of this up in a fair way. Anyway, one is that I think the act has been unequivocally effective. I mean, countless species have been saved from extinction. One recent study counted at least 300 directly at all taxa, from mammals to invertebrates. I think if there's any area where there is sort of systematic improvement could happen, and I don't think it would have to be statutorily. I think it could be administratively, would still be on private lands. And just as one stray example, we spend billions of dollars in taxpayer dollars every year for private conservation easements that the IRS approves that really could have a much better endangered species focus if we really wanted that to happen. There's other examples, but I think that's so. Number one, the act has definitely been effective. But number two, despite the fact that the architecture of the act, I think, is sound, it absolutely, as I think Derb and a few others have said, has suffered from this administrative lurching back and forth. I mean, just in my professional lifetime, Bush Sr., Clinton, Bush Jr., Obama, Trump, Biden. I mean, literally, it's like Groundhog Day every time we have these changes of administration with different political party. And it's like we just go through the motion, and here we are doing it again. We're doing exactly what we did essentially in the first years of Obama, overturning the George W. Bush rollback. So that takes its toll, and I don't really have an answer for that. I think that's the nature of the beast. I will say one thing. I think Bruce Babbitt is unequivocally the best Interior Secretary in my lifetime. I actually like him personally, and I think he's been. I think the one perhaps biggest mistake he made that's relevant to one of the points JB made was he put all the Fish and Wildlife Service into the National Biological Service, and then the National Biological Service got creamed, and we lost a lot of scientists. That was a very important point, and I don't blame him from doing that. It was a very rational gambit at the time, but we never went back, and the science has not been the same at the Fish and Wildlife Service since the early 90s, which is an issue that a couple of us have pointed out. And so I think the second point is the architecture of the act is sound. Obviously, fiddling can always be done. There's fine-tuning, absolutely can and should be done. The third point is, and a few people said this as well, I think JB, recovery is not only hard, I would argue it's more long even than it is hard. When you look at recovery plans, they have for a species, when they finally assemble a recovery plan team, 20, 30, 40, 70-year windows by which we're going to recover species. The act's only 50 years old. I mean, you know, and it took a long time to get species to the point where they're near extinction. So I think we do have to be patient or communicate that patience. That's a little bit related to funding, but it's a little bit related to scientific reality. So I think the greatest big picture existential threat to endangered species is climate change and fossil fuels, but that's another topic for in 20 minutes, and I'll end my opening remarks there.
Thank you, Bill. Because we're just talking about recovery, I'm going to try to take a few audience questions about recovery and bundle them together. So one participant says, is the way we define recovery part of the problem? Is it realistic to say a species is recovered when it continues to rely on human protection? And then we have another question in terms of failure to recover species. This person senses that, is it because as soon as a species shows any forward progress, there is political and industry pressure to reduce protections and in many cases resume direct hunting for species that are still very low abundance? Is that true? So I kind of just threw a lot at you, but if anyone wants to take either of those, please.
I'll go first with a very quick attempted summary of biologist Mike Scott, who I think all of us on the call, or many of us know who Mike Scott is for many years, was USGS, a great endangered species scientist. He has a book and many articles on the concept of conservation reliant species. And there's a number of them. And I think he very convincingly points out that if the conservation measures are enshrined in some sort of legal protection, then the species is recovered. And as long as we know that they're relying upon those measures, then we can sort of relax other protections for them. And I think, and that's not for all species, but I think for many of these mostly endemic, smaller range species, if they do have the conservation measures in place, yes, they do need our continued help, but I would consider them recovered on some level. I know there was more to your question than that, but I wanted to get that concept out.
Well, I'd even add to that, Bill, that the act itself contemplates that. In other words, the assessment of threat to the species takes into account the inadequacy of regulatory measures. And so if the regulatory measures in place are supporting the now viable species, I think that's perfectly consistent with the act itself. So, right, I mean, I don't think the act even contemplated that recovery meant recovery without the assistance of legal apparatus to bring about conservation.
Great. Does anyone want to speak to this component about industry pressure to reduce protections after a species shows progress?
Well, I'll just generically say, depending upon, I mean, industry is a large, whatever the affected industry is, if they perceive it as impacting their profits or their interest, they push back. That's been a constant, at least in the 40 years I've been involved with the statute. I mean, that's sort of like dog chases cat on some level. I don't mean to be disarming of the question, but yes, I think that's a huge dynamic.
I mean, I think that's right, Bill, in the sense that as soon as you delist, I mean, if you don't have Section 9 and you don't have the requirement to avoid take or to mitigate for take, then you're probably taking a step back every time a project moves forward. I think that is a tension in the delisting process. I would throw in maybe a slightly different from the question, but I'd throw in a perspective that one area of the act that's got some ambiguity right now that needs to be settled is recovery plans are declared to be non-regulatory, but they're starting to creep into some of the Section 10 permit processes. When the service realizes maybe this project with its mitigation is really good, but it may actually prevent certain aspects of the recovery plan from being reached. And what do you do then? As much as it's been billed as non-regulatory, it looks like they may start to drive permit denials or other issues like that. So I think it would help to sort that out, and it would help to better understand how you do move forward with delisting and still not take a step back.
Well, I'll throw in a little devil's advocacy here. The statute is designed to identify threatened and endangered species, to protect them through Section 9, Section 7, and then it's about permitting. It's about projects going forward, right? And so Section 7, federal agencies fund, carry out, and authorize land development and water resource development, other uses of resources. Section 10 explicitly is about permitting of land development and other actions not funded, carried out, or authorized by a federal agency. So it's recovery oriented, protection oriented, but also it's a permitting statute. And I think over time, that's what it has come to be. That's how it's being implemented. That's how the Supreme Court looks at it, right? And that's how other courts look at it. Now, I'm not saying that means we don't, implement Section 7 and Section 10 the way they're intended to be implemented, but we have to recognize that it is ultimately a permitting statute.
I'm not sure I would go along with that, in that the first stated purpose of the statute is to conserve ecosystems. I mean, I guess my response, JB, is to invoke former Justice Breyer, who said for any hard, fast rule, there's always an exception. Thou shalt not murder except in self-defense. And so I think these exceptions, you are right, there is permitting and there are exceptions in the statute, but you still have TVA v. Hill says the overriding purpose of the statute is to conserve species. And I think the permitting is subservient to the conservation, not the other way around. And I think that distinction is important.
I mean, I would agree with that. I mean, it almost takes us back to the fundamental principles in the 70s for all these statutes, which was to get folks to internalize their negative externalities, right? So that's where you're going to mitigate and offset your impacts. I guess the question becomes, when you do that, or even when you overachieve in doing that, and you're not even commensurate with impact anymore, but somehow something in the recovery plan won't be met, where does that fall? Is that a permit denial for a single project, or is that a more societal type of a burden or approach? And so I think that's again the tension between the two pieces of the act, that we're going to recover species, but we're also going to kind of stick to our rough proportionality and our landowner rights and everything else, and put them all in the hopper and come out somehow, with recovery and with projects.
I want to take one more audience question, just because we were kind of talking about it a minute ago before I go back to the plan questions. One participant was talking about how DERB was discussing the benefits of reversing Trump regulations, but many actions of the Trump administration were themselves reversing Obama actions. How can we prevent the next Republican president from quickly resurrecting the Trump regulations?
You can't, other than through statutory amendment, which I give a low probability. I'm being a little bit provocative there, but that's, as Bill pointed out, I mean, you essentially can't. Most of those, certainly guidances can be reversed perfunctorily. Regulations take a long time to reverse, but administrations know how to do it and have been successful. And executive orders can be rescinded with the stroke of a pen. So we are, it's not just the ESA, we are stuck in this world under so many of our environmental and conservation statutes in which we are, statutory, fixing the problems through statutory amendments or freezing particular policies is a very difficult process these days. So we're in this just, back and forth. So I don't know that the answer to that question is very satisfying.
It seemed to me that the last administration really kind of held back on their amendments, in my own view. I mean, I don't know if that's a political choice or the popularity of the act, but they were kind of working around the edges, in my view, that they could have done much more damage, both to Section 7 and other things they were doing. And it was almost, I think I described it as a nothing burger the first time it came out, just because of how little they had really done to the substance of, the consultation process. You can, and what we've been seeing is, one administration, like the Trump administration, will put in that the causal standard maybe has some aspects of proximate cause. Well, now we're going to take that back out. But the statute is still going to function about the same way. I think it's the same causal test we've always used. So it's kind of been interesting that way. I don't know if it's a political dynamic there.
I think there's a fair point there. And I think one thing that may have happened during the Trump administration was that, remember, we had two interior secretaries. The first one, Zinke, really was an administrative idiot. Like, he did everything wrong. All his decisions, most of them were thrown out. Bernhardt came in, had the same agenda, but was much more, was a former solicitor, was much more meticulous, and I think made some strategic decisions to get some things of their agenda done and not all of it. I think that's a part answer to Sean. I'm going to put DERB on the spot just because I know he deals with these issues all the time. I think the answer to your question, Shreem, is political. How do we make conservatives care about conservation is really what you're asking. or what the questioner was asking. And boy, if we could get the Republicans back to Teddy Roosevelt, that would be great. But that I think is ultimately the answer, because the Republican Party right now, it is the party of just big industry and just plow ahead at all costs. No Republican national leaders seem to care about conservation at all that I see.
Yeah, I'd jump in and say I agree with all these points. And the reality is, and we may get to this later, is Congress is not going to deal with this law. They are not going to go in and make fixes. I just think it's just a political non-starter, which means that the back and forth is going to be all administrative. And if parties change and the administration changes, you can expect these changes. There may be roles for courts in terms of putting some sideboards on how far a new agency under a new administration wants to try to go in terms of getting out of bounds in terms of what the act requires. And there's a 50 years now of not only administration of the act, but 50 years of case law that's been developed on what the act requires and what those sideboards might be.
Thanks, everyone. So there's some great questions about funding and listing procedures. I'm going to hold off on that for a little bit and get back to one planned question for the panel. The drafters of the ESA did not address climate change. Each of you has a slightly different conception of how the ESA can or cannot be leveraged to mitigate climate impacts on endangered and threatened species in the coming decades. Please talk about those views. Let's start with Bill.
Well, I'll just start. We could talk about this for a very long time, and I'm sure we'll spend some time. Let me just start, since I'm first, with a couple legal points I don't think anyone can disagree with. First is that one of the listing factors, a reason why a species must be listed, is for other natural or man-made factors. Congress was very aware of the fact that many things cause species to decline. And to me, that clearly covers climate change. That's not a major question as far as I'm concerned. I think that's a pretty large window. And then to sort of buttress that window is the conservation. This is the dialogue I was having with JB. Conservation is the overriding objective of the act. And not only is it the objective of the act, it is an obligation of all federal agencies. And since all federal agencies have some impact or are impacted by climate change and greenhouse pollutants, it seems to me that it's unavoidable if there is causation, and that's the big F, which I'll just sort of leave hanging, then unquestionably climate is something that the Endangered Species Act should address. It doesn't mean the Endangered Species Act becomes an emissions statute, but it is a statute that says if greenhouse gases and climate change are impacting a species, we need to have a game plan on what to do about it. You can't just stick your head in the sand and pretend, oh, that's out of our gambit, we're just gonna, let the species go away. So I think climate change unquestionably is a part of the act. I think for some species, how it's actually implemented, I agree, it's not always straightforward or really easy. And I won't get into, I'll let the others sort of dive into some of those details.
Ron?
Well, I mean, I think that for me, it's really all about supporting adaptation and trying to work with the preserves that have been built in the large blocks of public land. In other words, I don't know that, as kind of Bill said, it's really not the vehicle for regulating greenhouse gas emissions across the board. I mean, do you capture a big project, a big federal project that maybe was already into Section 7 because it had habitat impacts, and now you manage to address this threat, but I don't think that this statute would be able to grab all the projects that it would need to make any difference at all. And of course, it doesn't have an international reach, so it's a little bit the wrong vehicle for that. And of course, we just talked about its kind of political capital or whatever is keeping this act alive would certainly take a hit if it starts to just regulate greenhouse gas emissions as an indirect effect, even for projects that, for example, are taking place in existing paved areas. The Act's unlikely to grab those, and probably wouldn't would receive a lot less support, I think, if it did. So I think, again, it's back to building on, especially in the West, on some of those regional habitat preserves that have been built, and connecting them to public lands, and then managing all of it for biodiversity, essentially. So that's kind of my view of where the ESA can help on habitat.
Herb, let's go to you.
Yeah, it's always been interesting to me that the Congress directed that key decisions under the Endangered Species Act be based on the best scientific information available. As a lawyer, it's almost arbitrary and capricious without that direction to make a decision that's not based on the best scientific information available. But here Congress has said that's what you have to do. It's a mandate of the Act. It applies to listing, critical habitat designation, Section 7 biological opinions. There's legal wrangling now over whether it actually applies to recovery plans or not, but it's very embedded in the Act, and there's been a fair amount of litigation, climate-related, that go back to that mandate and that requirement. So I would argue that if climate change considerations are already firmly not only embedded but required by the Act, because the uncertainty that used to be the cover for this is all being peeled away. The science of climate change is becoming much more certain, much more precise. It's being stepped down to secondary effects that are occurring on the ground that affect species. So I would argue that requirement to consider the best scientific information available in all these key decisions now requires us and Fish and Wildlife Service and those involved in Endangered Species Act decisions to fully factor in how climate is affecting a species as it relates to particular decisions that have to be made, whether it's listing, critical habitat designation, biological opinions, or probably even recovery going forward.
Go ahead, JB.
Yeah, so I think there are two big dimensions to the question, or the answers to the question. The first, I agree completely with everyone else, and Sean used the term helping species adapt. Absolutely. I think there are tools within the Act that may require a little bit of innovation, but not so much innovation that we're running into major questions, doctrines, or Chevron, if whatever post-Chevron world looks like. So in past writing, I've argued, for example, that when considering where to locate mitigation, and now we can do that under Section 7, but why wouldn't we want to think about where the species range is moving under a 50-year time frame for climate change, and consider those lands that aren't presently even occupiable by the species, but which we expect will transition into that kind of habitat? That should be fair game for mitigation. I argued, and the agency has dabbled in it a few times, that critical habitats, same analysis, right? If the species is losing its habitat on the southern end of the range, and the habitat's moving into the northern new areas, isn't that what is essential for the continued survival of the species over that long term? I think after Weyerhaeuser, that's problematic. It has to be habitat before it's critical habitat, and we haven't seen that resurface. I agree that greenhouse gas regulation is not where the statute should go. That probably would run smack dab into major questions doctrine if anyone tried to use the statute to directly regulate. I think there are some real big problems that we're going to start facing, and that is as we start listing more and more species primarily because of climate change threats, they're protected under Section 9 for any other harm, take, whatever. And so that puts a lot of pressure on those other potential sources of take that aren't the primary source of threat to the species. And I could foresee conflict and controversy over that. The other is that as species ranges move, the species move with them and may be entering existing ecosystem assemblies that, now we're not talking about invasive species, we're talking about adapting species, and how do we deal with those conflicts? The other big dimension to me is how we think about saving species and us through decarbonization. And decarbonization is going to involve a tremendous, unprecedented amount of infrastructure at massive scale over an urgent 25-year time frame. And we need to think innovatively and creatively about how, when those infrastructure projects do intersect the ESA, and it's certainly not just the ESA, we can get those projects done efficiently. No is really not an option for decarbonization infrastructure, but how do you say yes and still meet the conservation goals of the Endangered Species Act? We had a great pulse of innovation under Secretary Babbitt. I think we need another pulse of innovation that balances that very delicate problem of saying yes to infrastructure because we don't have a choice, but saying it in a way that is still consistent with the Act's goals.
Bill, did you want to respond?
I did. First of all, again, that was everyone. It was all really good, and I don't think I disagreed really with any of it. There's a lot of nuance and detail, and let me give two examples that I think provide a little more detail to what we've been talking about. The first is, as an example, the Willow project. The Biden approved this huge oil and gas project in Alaska, monumental amount of fossil fuel emissions. If, for the reasons Derb identified and talked about, we could actually link in a scientific way that project with jeopardy to the polar bear, to me, that's a legitimate linkage there. That's not the agency acting as an emissions agency. It's an agency saying that pollutant, just like that toxic spill, is going to harm the species. And if it's jeopardy, it's jeopardy. So that's one example of causation. Sean talked about that as well. On the last point JB just made, which I think is fair and I think is important, and clearly something that has been debated hotly in Congress, something for which neither party agrees with each other or within itself. There are huge divisions on this issue of streamlining permitting. I'll just say this. I agree that there ought to be a priority on an expedited basis to get good renewable projects through. But the reality is there's a lot of bad renewable projects. There was a project the Trump administration approved, William Penley, literally at the 11th hour and 59th minute or 23rd hour and 59th minute of the Trump administration, would have put miles of solar panels in prime desert tortoise habitat. So when you looked at the project, just, like a front line, like, oh, wow, enviros want to kill solar panels. But it was the worst place to put basically an industrial solar park. And some people opposed it. And the project was modified, thank goodness, as a result of that. So, sometimes the permitting in the process leads to, in fact, frequently, always leads to a good result, where maybe the original project was not as good and the endangered species consultation, helps guide it to a better result. Those solar panels were eventually built, by the way. So I just think that permitting issue it's loaded. It has so many permutations and it really is incredibly fact specific.
I didn't suggest it would be easy.
Let's pivot to a discussion of funding. We've kind of been dancing around it. Let's face it head on. So as we all know and have been referencing, ESA programs are chronically underfunded. And there's a lot of implications to this: listing backlogs, recovery plan, and critical habitat designation backlogs. Meanwhile, the Biden administration has both proposed and recently finalized regulations concerning experimental populations, monitoring and adaptive management for HCPs, expanded requirements for compensatory mitigation for incidental take. The point being, if all of these existing and proposed programs actually received the funding they require, would that obviate the need for congressional amendment to the ESA? Let's start with Derb.
Well, I guess my starting point on this is we shouldn't even at this point politically think about any action by Congress to come in and fix anything that's broken or could be improved with the act. I mean, you got a majority party that can barely even elect a speaker, much less the bipartisan effort that would be required to step in and help fix any problems or issues that exist with the current statute. You know, I look back just out of interest, and in 1973, the Senate passed the Endangered Species Act unanimously. Congress passed it 390 to 12. I can't even think of any action that has any controversy that this Congress can address. And unfortunately, at least for my horizon, I don't see any fix to that coming anytime soon. So I think all the foreseeable changes and tweaks and fixes are going to have to come administratively. And as I said initially, this act has been pretty resilient. You know, Secretary Babbitt's been mentioned for innovations related to habitat conservation planning, candidate conservation agreements, safe harbors. I think there are ways to administratively make the act work better, and that's what we're going to have to rely on. Funding is a key issue, and that's Congress. So we're going to have to hope that Congress can recognize that there's a need for funding of these administrative initiatives, and that funding is at an adequate level. This has always proved to be a very popular law. And I think when the American people weigh in, if they're given that opportunity, they'll support increasing funding that's necessary to achieve a lot of these objectives and address a lot of these challenges.
You know, it's interesting, Charmaine, you mentioned a couple of the changes lately or the amendments that we're going to see. For example, the HCP policy for adaptive management, which has been around since 1999, I believe, and has actually been required, but it'll now get codified in the regs. That's actually not, that's essentially project proponent money. I mean, that's really the the private landowner fulfilling the mitigation, and it's part of the mitigation. So it's really already funded essentially. And really the extension of compensatory mitigation in Section 7, it's either going to be a non-federal project proponent who needed a federal permit, or it'd be the federal action agency, which, when they're budgeting for projects like that, that money tends to show up, the compliance money, more easily than, say, conservation dollars. And so if we're really talking about conservation dollars, I think for me, the bottom line is it's kind of that expression from real estate when talking about coastal land with coastal views. They're not making any more of it. And so I think that's where our focus is to acquire as much habitat as we can. And so I think for me, it's about explicitly harnessing these programs like 30 by 30, the pilot project that's out there now for legacy barriers on infrastructure projects so that we can connect habitat again. All these ought to be explicitly directed kind of first and foremost to endangered species. So that's kind of the low-hanging fruit on this whole thing is let's enlarge the HCP preserves, let's connect them to other protected lands. There's a very effective program in Section 6 of the Endangered Species Act, both to fund the preparation of regional plans. That's why we have them. They were too expensive for counties to do this on their own. But the other piece is Section 6 has recovery land acquisition. And it's not mitigation, so you can't subsidize your mitigation, but you can build on your preserve once you've mitigated. And I think that's where we need to see a real effort is to fund acquisitions around HCP preserves. And also, I think in environmental forum, Melinda Taylor had a good suggestion, which is, right now, the Safe Harbor program, it just says you won't get punished for good things. In other words, you can return to baseline later after you've recovered some habitat or done good stuff on your land, but there's no real financial incentives to do that. It's just that you're going to get regulatory relief later. And Melinda suggested, in fact, we could incentivize a lot of voluntary conservation, maybe something different than the sale of conservation easements, right?
And I think I'll just add a sort of higher level perspective. I think that question reveals a tendency many of us who are interested in conservation have to expect too much work out of the ESA, right? It goes back to Derb's point that really when you step back and ask, what are we really trying to accomplish here? It's conservation, it's protection of biodiversity. And let's think of the ESA as one player, one, tool we have. There are other tools that probably, as Sean has put a little meat on that concept of integration, could attract more funding and go a long way towards contributing to that overarching goal. And so I think we tend to think of the ESA as going to solve this big problem. It's not an ecosystem management statute. It's a species conservation, species-specific conservation statute, but it can play into a larger scale and broader framed ecosystem management, biodiversity conservation agenda. We may find funding. We already see evidence of funding for that. Easier to get through this extremely polarized Congress than asking for more money for specific ESA programs.
Again, I think all fair points. I have three really quick points. One is I think the act is sound. I don't think the act needs amendments. I mean, even if we could get it through, I think the architecture is sound. I think this is really about implementation. Yes, we obviously need more money. We all agree with that. I think JB's point is a decent one. And I think there have been funding proposals in Congress that would do that, that would take that wider look that Sean was mentioning. And some of those bills have been bipartisan. And a little bit of the Inflation Reduction Act had some of that, although not as much as some of those other bills. And then just in terms of what really does need to be done by Congress, I do want to talk about the easement program again, because it's not only the program that the IRS administers. We're talking about billions of dollars a year, billions and billions and billions. But it's state easements, it's federal easements through the Department of Interior, Agriculture. I mean, they are all probably, there's always maybe a bad easement here and there, like, Trump's golf course, but by and large, 99% of them I think are good, but they are completely incoherent. There's no overarching examination of them. I think USGS could be empowered administratively to do something. I think Congress should probably clean up the federal easement law, but has no real inclination to do that. And then the second thing is the public lands. I've admitted private lands are a challenge for reasons on how our Constitution and society are structured. Not undoable, just slightly more a challenge. But on federal public lands, it shouldn't even be an issue. All those agencies have clear conservation duties under the Act. I get that the Forest Service and BLM are multiple use, sustain, yield statutes, but that should never interfere with the conservation of endangered species. I think the Endangered Species Act in public, it's no longer really about the northern spotted owl, although that issue is not resolved and there still are some northern spotted owl issues. I don't mean to demean that issue at all. It's a real issue. But when you look at public lands across the country, by far the greatest threat right now is fossil fuel extraction, unequivocally, when you add it all up. And that leads us right back to the beast of big industry and what's really driving this thing, and why it is we can't get meaningful protections for, like, the sage grouse. Why that's so difficult. It's difficult because there's a huge entrenched interest on the other side fighting tooth and nail.
While we're on the funding piece, I want to take one audience question. This person observes that each action agency is responsible for Section 7 using their own funds. NIMS and Fish and Wildlife have funds to implement restoration projects and not deal with the day-to-day impacts. NIMS and Fish and Wildlife are short-staffed, they have long backlogs, as we've discussed, but they're very different, three different buckets of funds, this participant points out. So where exactly do you see the shortages, and how would you propose that additional funding gets allocated?
I'll just do one. I think listing that we need more funds to list species that are clearly in need. Dirk mentioned the longer we don't list them when they're in need, the harder recovery is, the greater likelihood of extinction. So even though I think part of the listing program could be dealt with administratively, Congress has been very, very they've limited the amount of money they give to listing, and that has had a huge impact on really being scientifically sound about our protection. So that's one. I'll let the others talk about the other two or three.
I mean, I think really the funding recovery plan implementation tasks, that if you don't fund them, then you're just writing these plans and putting them on a shelf. And so I think that's the big piece. And I think it may be not even recovery plans as much as, it's recovery plans, but now we're seeing like these big adaptation policies by Fish and Wildlife and NIMS that are more comprehensive in that sense. And I think, fully funding that type of stuff as well. And then we have the Section 7A1 for federal agencies, that not just NIMS and Fish and Wildlife Service, but the notion of, how much more money could we actually direct towards public lands? For example, that new BLM policy I mentioned, that'd be perfect thing to fund is protecting intact ecosystems and restoring degraded habitat. And so that for me is where the money ought to go.
Let's talk more about listing. There's a couple great audience questions on listing. One audience member asks, what do you think about the view that the service is reluctant to engage in listing species, as it often results in a contentious process that invites litigation, but diverts funds from the goals of the ESA? Is that accurate? What can we do to address that concern without taking away the strength of the Act in allowing citizens to challenge rules or lack of rules?
I think it absolutely is a dynamic, but it really depends on the species. Every species has its own story, but I do think the service, as a general rule, has its own game plan. And if there's a species in need that's not in their game plan, sometimes that species will suffer. I also think sometimes the service counts on litigation to help it do some of the hard work, perhaps sometimes.
A related question about the listing process. An audience member points out that the process has gotten Byzantine. It's literally designed at this point to miss the ESA's 90-day and 1-year deadlines. What can the service do to eliminate duplicative review and design a process that approaches, if not actually meets, the ESA's statutory deadlines?
I think Sean worked there. He's got to answer that.
Well, I think the part of it for me is that 90-day, the 90 and the petition and the 12-month finding. Is that really all that Byzantine? But I think first of all, it is a funding issue, but also what was sometimes showing up is that the federal agency may already have put this on their list for warranted to be listed for whatever reason. And then you get a petition and back, at a certain point, it could just be written with a crayon. It didn't have to have any other new information. And it just, and it forced the service to reprioritize their listings, even though they already knew exactly what that petition told them. And so I think that's been part of the problem, is the species du jour, why we saw that for so long and of course, this is the other thing, is that the agencies do pay when they lose Section 4 listing decisions. And for the longest time, these were missed deadline cases. And so for organizations looking to build their capacity, it was an easy source of revenues to go challenge these missed deadlines. And so I think that's when we finally saw this kind of effort to do the listing priority guidance, and then eventually to try and at least get courts to force kind of mega settlements and to get this master list of species sequence, so we can get rid of that litigation. It was really almost in one sense, almost abusive of the process if you were really, paying attention to what was already trying to happen.
And I'd add that if let's say we took a bunch of biologists, a group of biologists, and put it, completely outside the ESA and said, go figure out the status of this species. We think it might be on the way to extinction. Figure that out in 90 days, yes or no. And then within 1 year, figure it all out. I think they'd say, well, why 90 days in 1 year? Well, that's not how science works. There's not some, more funding, we could get more, but why 90 days in 1 year are the magic numbers we must fit listing into? I can't fault the agency if they, at the end of these timeframes, say, well, we don't have an answer yet, right? I mean, so yes, we want the agency to work expeditiously, but I think what happened was science kind of got in the way. As Derb pointed out, they have to use the best available scientific information. And if they're legitimately trying to make these decisions based on that, and they can't make it within 90 days and 12 months, then that's problematic if that then opens the agency up to litigation and recovery of attorney's fees.
I agree with in response to the basic question, that listing and recovery are where more funding is needed, particularly implementation of recovery. And I would hope that we could figure out some way to deal with situations where if you've got a river that has we're in the part of the country that's got the richest aquatic biodiversity in the country and really in the world. And if you got a river that has a mussel species that is warranted to be listing, I would put my resources there if I were trying to, making a decision in a rational way. On the other hand, we have rivers that have not only 1, but 2, but 3, but 4, but 5 listed mussels. So you're putting a lot of effort into listing mussels in the same river that if you put the effort into recovering the first one that was listed, we'd be making a lot more progress. So it's hard to control all of this, but I think there are ways I would hope we could figure out to more efficiently spend the funding that is coming in to both list species that need protection, but also really work to recover those that can actually, turn down the faucet of those additional species that may need listing because you're not working to recover those that are already in need of funding and work. And let me just add one thing. This kind of gets back to Congress too, is in our region, in the Southeast, where we've got such a rich aquatic biodiversity, a lot of listed species are aquatic species, and there are more that warrant listing. There's a big backlog that's being worked through of just aquatic species in our region. And then in the midst of all this, you had our Supreme Court legislate a new definition of wetlands under the Clean Water Act that is likely to eliminate protection of significant areas of lands, wetlands in particular, that have been protected for a long period of time. What does this mean for the Endangered Species Act? Well, for many species, Fish and Wildlife Service has leaned on that protection as another regulatory mechanism in making listing and delisting decisions. One is pending to delist the wood stork in our region that's highly dependent on isolated wetlands. There's another recent decision not to list Venus flytrap in our region, which is a plant that is highly dependent on wetlands that are probably at the most risk for this decision. So do I expect Congress is going to step in and restore those wetland protections? Probably not. But it's going to have a big spillover effect in our region related to the Endangered Species Act, because these species are dependent on those areas, and Fish and Wildlife Service has relied on that protection for many years in making various decisions under the Act, particularly listing decisions.
You know, one point that pertains specific, that was really a good pointer, because it does show, as JB was pointing out, that the Endangered Species Act should be at the end of the, there's many other reasons habitat gets destroyed, and the endangered species, the ESA is all that's left really at that point sometimes, and public land suffers the same fate. But I wanted to point out, in response to something JB said, which I think is fair on a certain level, that the 90-day and 1-year findings for some species may be fast, and the agency, in the interest of best available science, does genuinely need more time. I would argue that that's actually how the process works now. Yes, there are 60-day notice letters that are filed, but they invariably result in discussions and prioritization, sometimes in lawsuits, but just as frequently not lawsuits, because it opens up the dialogue and discussion of what the priorities of the service are. In fact, it's one of the jokes of 60-day notice letters, at least in the 21st century, that, it's not as though you're going to resolve that lawsuit, but when ESA listings, 6-day notice letters still do sometimes serve that function of helping the potential litigants and the agency open an official dialogue about what the species priority truly is. And maybe JB, you've done recent research, but I'm not aware of any group anymore doing cottage style 91-day lawsuits. All those 90-day lawsuits are only after there's been a discussion back and forth, and the agency, for whatever reason, well after 90 days is deciding not to move. I'm sure you can find 1 or 2 exceptions, but all the cases I'm aware of, even the environmental groups, take the 90-day and 1 years. They take it seriously, but recognize from a matter of administrative law that judges are going to see sometimes that those agencies are being overworked and overloaded, and if they've got a good excuse, they usually can get away with it. So I think that part of it has actually turned out okay, even though we shouldn't have to I agree, it would be better if the service just had an actual prioritization system and scheme that everyone could buy into, but we seem not to be able to do that. It should be, if it's really just about science, it shouldn't be that hard to do that, but as it turns out, it's very hard to do.
Yeah, I didn't mean to suggest that the kind of litigation Sean was describing is continuing at that magnitude. There was a period there where it seemed to be a new lawsuit every day on that. But yeah, my point was simply that 90 days and 1 year are, there's nothing scientific about them. They are arbitrary timelines that we're trying to wedge science into, and the agency's doing the best it can. And it may be that a 60-day letter is a litigation-driven way of reprioritizing where the agency directs its resources. That's not an ideal system. So I was just, more funding might make more 90-day and on-time 1-year findings for sure, but it's a scientific inquiry at bottom.
So we have about 12 minutes left. I think we can squeeze in some more of the many great audience questions. Derb had just started talking a bit about SACIT and that's the implications of SACIT for species protection. One participant asks, what are some vulnerabilities of the ESA before this Supreme Court? Do you foresee a constitutional challenge to the ESA making its way to the Supreme Court?
Well, my contribution to the forum debate hypothesized a world in which Sweet Home versus the Sweet Home opinion had not happened, and that the challenge to the harm definition came up today. I think we'd see the kind of outcome that we saw in SACIT. Justice Scalia would win again, and I suppose, as we saw in SACIT, someone could challenge the harm definition today, and particularly after what we expect will happen in Loper with Chevron and whatever the post-Chevron world looks like. I think it's precarious. That's the kind of precarious situation we find ourselves in today. And I think that bold action like, I'm sorry, Bill, but if the agency starts regulating big emission projects, we're going to see a major questions doctrine suit filed right away, and I think it's going to run right into it. There's no way coherently to tailor GHG emissions under the ESA, same way there wasn't under the Clean Air Act. And there's just very little to grab onto in the ESA to suggest that the Fish and Wildlife Service can start regulating, basing decisions on GHG emissions. So I think there's a whole host of issues out there that the current Supreme Court jurisprudence is throwing into some precarious context.
I want Derb to respond to the larger Supreme Court question, but just on that last point, I think that's fair. I'm nervous about the major questions doctrine too, but what I was talking about was a denial is a jeopardy finding that involves a consultation process, and a jeopardy finding that has the God Squad at the end of it because of the TV v. Hill litigation. So I actually think the statute anticipates some of these hard questions, and so I think the ESA would totally still be in its lane, so to speak, to deny to give a jeopardy opinion on a massive oil and gas project that clearly is going to harm the polar bear. I actually don't think that's major questions. I hear the larger policy concerns, but on that narrow, that doesn't mean the oil and gas industry wouldn't try that case. I hear you on that.
Well, we can go back and forth on that. What would the post-Jeopardy decision world look like? Which carbon dioxide molecules are not thereafter regulated as more jeopardy? So I think you're opening up a big can of worms with that. What sounds like a straightforward application of jeopardy under Section 7.
Arguably a bigger can of worms if we don't ask those questions. But anyway.
And the panelists speak to particular opportunities they see for additional federal partnerships and improved coordination with regional entities, state agencies, academia, and industry in implementing conservation and recovery programs.
I mean, I think we talked a bit about the importance of the public lands to the Forest Service and BLM, and I think there's lots of opportunities. There's so much public land west that some of the HCPs have difficulty mitigating on non-federal land. And so Clark County is a good example with desert tortoise and numerous other species in their MSHCP. They're essentially developing land that gets disposed by BLM. Meaning it's released from the federal public lands and becomes private land, but they're only disposing of a certain amount of land and that's all getting built on. And so where do you mitigate? And so you're mitigating really on public lands. And so it requires this type of partnership with BLM. They've worked hard on that. The Desert Renewable Conservation Plan a while ago kind of worked on what happens if the mitigation on public land gets undone because it's not protected in perpetuity. So there's policies to address that. I think that's important. But I think somehow tying into, where an agency like BLM is launching some conservation proposal or some new approach to managing public lands for biodiversity, that needs to really be, hand in glove with the Fish and Wildlife Service and National Marine Fisheries Service. And so again, it may be that the connection there is Section 7A1 funding so that it really is an Endangered Species Act component to it. Maybe the Fish and Wildlife Service and NIMS are, part of what is lobbying for that money for BLM.
Yeah, I agree. And the older I get, the more I really buy into and I've come to understand and realize that when parties really are engaging and communicating in good faith, good things happen. And sometimes parties do get sort of boxed in corners they don't mean to be in. That being said, sometimes parties are like Clive and Bundy and just not manageable, and you can't reason with some people. So there, when that communication and cooperation works and when you need to just drop the hammer is always an interesting question. But I think a lot of actors, I think more communication on private land conservation, the way we've all been talking about, would help all parties. I definitely think that's a conversation still in process, big picture process.
Yeah, and I'd go back to Sean. Sean's mentioned several times Section 7A1, and I think that's just one of the, I've thought this for decades, I've written about it, one of the big untapped potentials. And I think it could be a way of galvanizing federal agencies into more collaborative partnerships. I mean, there's just no obstacle to it under Section 7A1. More funding. I mean, the case law is such that it just doesn't. I mean, if the case law remains as is, it has no real regulatory teeth, except in very limited circumstances. But it could be. It doesn't have to have regulatory teeth to do what Sean is describing at all. In fact, that's maybe part of the beauty of it. And I would just remind us that ChatGPT thinks collaboration and partnerships are one of the great success stories of the ESA. So we ought to stay focused on keeping that success going.
One audience member is curious about funding for and enforcement of the ESA's criminal provisions to support the goals of the statute. And that's not something I hear discussed much. Do any of you want to speak to the ESA's criminal provisions?
They're not used very often, as far as I know. Someone may be more expert than I, but I think it's a relatively rare phenomenon, although I confess I don't have the numbers off the top of my head.
No, and you're right. And not only that, Bill, but it's a misdemeanor. And honestly, you go into the U.S. Attorney's office with a misdemeanor and they're kind of busy. I mean, they really, and even that staff attorney's not really evaluated much on misdemeanors in terms of their own professional advancement. And so they're not very well received when you try and bring them. I think the more important aspect of the enforcement program is injunctive relief. And there have been a handful. And I think, and I remember in the Southeast, it was at a period of time when there were no Section 10 permits. It was kind of fairly new to the Southeast. And it really was kind of just a matter of trying to get a culture of compliance, the notion that a permit's required. And so, injunctive relief is really important in that aspect. The other interesting kind of component that sometimes causes compliance in the ESA is really almost the threat of an injunction from the perspective of the lender. So, and I think JB might remember this, but the old bird letters in Austin, the no-take letters that you had to kind of show to your lender to get them comfortable. And so that there was this notion that there was compliance required even though nobody was knocking on the door. I think that's an important, has really been important for the act. And of course, out in California, it's really hard to assume the risk of Section 9 because the state equivalent of NEPA, the CEQA provisions, they just flag it. You just can't really move forward without somehow having addressed it in a compliance-oriented way, so that we see other laws helping compliance there.
Maybe just time for one more question. Kind of wraps up some of the things we've been discussing. For the past 50 years, the ESA has largely functioned as a stick to prevent extinction. What opportunities do you see for the ESA to become more of a carrot to incentivize recovery of endangered species and enhancement of biodiversity?
I'll go first. I think actually Bruce Babbitt, one of his many strengths was that he began that process. So I think actually that was true up until the late 90s. I think Babbitt helped change and Sean's team helped change that. And I think there are so many other private land mechanisms, including SACIT, including the IRS, that's where the game is. That's where the opportunities are. And it's not all going to be about sticks. That's a part of that communication and dialogue and fixing problems. But it's not going to be easy. It will take some effort.
So far, conservation banking is the only area where you could actually think about making money on endangered species, and banking is really difficult. And so, number one, either you've got to somehow make conservation banking easier, but also kind of what I was talking about earlier is maybe there's other forms of payment to landowners that they're not selling credits, they're not trying to bank credits, they're just going to do something good for a while. Maybe as a component of a safe harbor where they get to go back to baseline later, but they also made they got some kind of compensation for it. And it's kind of equivalent to Bill's examples on the NRCS easements and stuff like that. That get a short-term easement, maybe there's something tangible for you in doing that. And that would be certainly a very helpful carrot.
I think we're just about out of time, and there were so many audience questions that are really wonderful that unfortunately we couldn't get to, but I'd like to thank the panelists for their wonderful participation and the audience as well. I'll pass it to Madison.
Thank you so much to our wonderful speakers today. Thank you to Charmaine for moderating, and to JB, Bill, Derb, and Sean for their engaging and thoughtful commentary. We so appreciate all of you joining us to speak about this important topic. To our audience, thank you for spending your time with us this afternoon and for your many questions. We're sorry we couldn't get to all of them. There were quite a few. As a reminder, if you were unable to attend the full event, ELI members will be able to watch the recording on the event webpage within a few business days. We hope to see you at future ELI programs. You can find all of our programming at eli.org. Thank you all, and we hope you have a great day.
Thank you.